Historical background of special education. This lesson is to provide information on how historical events have impacted special education policy and procedures. Where did we come from and how did we get here? So once we go through this lesson, you should be able to explain why it is important to know about historical events when trying to understand the current status and future of special education. Explain the impact and importance of the civil rights movement in relation to the passage of pivotal special education legislation. In this lesson, we ask the question, why is it important to know where we came from? Why is the history important? For one, it helps to prevent us from repeating mistakes, which is very important in special education. We want to move forward, not stay stagnant or go backward. It is essential to have knowledge of the historical events and factors that are related to special education law in order to understand the current status and future of special education law. We cannot understand today's difficulties very well if we assume that they emerge from present circumstances alone. Although knowledge of history is no guarantee that we will not repeat our mistakes, ignorance of history virtually ensures that we will make no real progress. That's a quote from Kaufman and Smucker, 1995. History is important. Special educators should understand historical events related to special education to understand special education in the present, make informed decisions to support students, evaluate future proposed special education laws and policies should you be asked to provide your opinion or make a prediction on a trend. Avoid repeating past mistakes. So going back to the 1800s, the federal government provided grants so states could educate visually impaired and deaf children, and that was kind of the beginning of special education. As we look at a couple of notable figures who were involved in the beginnings of special education, we're looking at Jean-Marc Gaspard Attard and Edouard Seguin. And these are not educators, but physicians. So Jean-Marc was a French physician who worked with deaf children. He was credited with the first notable recorded attempts to educate a child with severe limitations in a structured manner. And Edouard Seguin continued his work with children with mental challenges. And these two men started the basis for special ed and worked with pieces that we still use today. So starting back in the 18th century, they were using individualized instruction, carefully sequenced series of educational tasks. They had meticulous arrangement of the child's environment. They gave immediate reward for correct performance. They did tutoring in functional skills. And they had a belief that every child should be educated to the greatest extent possible. And I want to read very quickly from Legal Aspects of Special Education by Kurt E. Hullett. The beginning of special education can be traced back to the 18th century. The field is rooted in the work of physicians, not professional educators. Although the United States has made the greatest strides in nearly every facet of educating children with disabilities since the latter half of the 20th century, it was the work of non-Americans that initiated the humane treatment and education of children with disabilities. Several European scientists engaged in the observation and study of deviant behavior and gross abnormalities. These individuals broke from the traditional thought and practices of the era and attempted to educate children who were considered uneducable. As Kramer contends, these European physicians questioned the practices of their contemporaries and colleagues through their revolutionary ideas and practices. So starting back with the Civil War era, President Lincoln issued the Emancipation Proclamation to free American slaves. So we're starting back to talking about equal rights. And that happened back in the 1800s, 1863. After the Civil War, Congress passed and sent 3 amendments, the Civil War amendments, to the states to be adopted, the 13th, the 14th, and the 15th Amendments. In 1865, the 13th Amendment was passed, which abolished slavery and involuntary servitude. In 1865, the Southern states responded by passing the Black Codes, which were intended to limit the rights of African Americans. In 1866, Congress passed the Civil Rights Act, and the act made it illegal to discriminate against individuals on the basis of prior servitude, race, or color. In 1868, the 14th Amendment is passed, which guaranteed the right to life, liberty, and property. It guaranteed all persons the equal protection of the laws. And in 1870, the 15th Amendment guaranteed that all American citizens the right to vote, no matter what their race, color, or previous condition of servitude. In 1875, the Civil Rights Act was passed, giving all black citizens the right to equal treatment in public and on any public transportation. In 1865, the federal government worked hard to protect the rights of African Americans, but there were a lot of political changes, and many of the laws previous to this were nullified or repealed. In 1883, there was a civil rights case, and the Supreme Court declared the Civil Rights Act to be unconstitutional because laws covered by the Civil Rights Act were left up to the individual states, and the protection of rights guaranteed by the 14th Amendment applied only to the state and not to individuals. So as a result, it was legal for private individuals to continue to discriminate against African Americans. So we made some progress, then there was some backsliding. There were more political changes, and many more civil rights laws were nullified. In 1896, there was a case, Plessy versus Ferguson, and basically the summary of that case, there was an African American man who rode a train in the white car, and once that happened and he was taken to jail, he brought a case up and said it was illegal to discriminate against him. But the Supreme Court declared it was legal to segregate individuals and have separate facilities as long as those facilities were equal. This reinforced the practice of segregating and discriminating against students who deviated from the norm, and that included children with disabilities. So this ensured that the 14th Amendment would not provide all Americans equal protection of the law. And this would not be corrected for about 58 years. And I've provided you with a link to go back and read a Jim Crow story about the Plessy versus Ferguson case, should you be interested in doing that. In 1919, there was a legal case, a student with a disability that caused the student to drool and have involuntary facial contortions and speech problems. It was strictly physical. His intellectual ability was not affected, but he was expelled from school because this condition nauseated the teachers and other students. The case went before the Wisconsin Supreme Court, and the court ruled that the school officials could indeed exclude students with disabilities. So it's become a total struggle. So now not only are we looking at African Americans or people who are being discriminated against because of the color of their skin, but also because of their disability. In 1922, the Council for Exceptional Children was founded, and this was established by students and educators who were concerned with the education of children with disabilities. This group became a really powerful group and was integral in the advocacy of special ed legislation. In 1950, the National Association for Retarded Citizens was established, and yes, that's an old term. In 1954, Brown versus the Board of Education was a catalyst legal case. It overturned Plessy versus Ferguson, and the decision in this case was the start of litigation and legislation that provided individuals with disabilities equal access to free and appropriate public education. And it took a lot of years for this to be implemented. And this was a case that was not related to disability but to discrimination based on color. But because of the summary that resulted in desegregation of all public schools, a lot of people started using this case as their basis for a case against discrimination related to disabilities. So this was a really important case in the movement towards equal access for students with disabilities. So finally in 1960, after all this time, Ruby Bridges was the first black student to attend an all-white school. In 1964, the Civil Rights Act forbid racial discrimination and guaranteed that all people will have equal access to hotels, restaurants, and other public places. In 1966, the Elementary and Secondary Education Act Amendment, PL 89750, created the Bureau of Education for the Handicapped, which later became the Administration Agency for Education of the Handicapped Amendments and IDEA. This bureau is currently the Office of Special Education Programs, and this is the office that brings down the federal laws and interprets and writes the regulations and then passes them on so that the rules can be written for states. So the Office of Special Education Programs is a really important agency for special educators. So the next thing was in 1972, Park versus Pennsylvania and Mills versus the D.C. Board of Education. As a result of the Brown versus Board of Education case, there were a number of court cases filed based on that decision on behalf of persons with disabilities. The Association of Retarded Citizens, or PARC, versus the Commonwealth of Pennsylvania happened in 1972. This was a suit brought against the Commonwealth of Pennsylvania in a federal district court. The suit names the state's secretaries of education and public welfare and 13 school districts, and it argued that students with mental retardation were not receiving publicly supported education because the state was delaying or ignoring its constitutional obligation to provide a publicly supported education for these students, thus violating state statute and the students' rights under the Equal Protection of the Law Clause of the 14th Amendment of the U.S. Constitution. And they said children with mental retardation are capable of benefiting from a program of education and training. Education cannot be denied or defined as only the provision of academic experiences for children, but they should be learning to clothe and feed themselves as outcomes of public school programming. That having undertaken to provide all children in Pennsylvania with a free public education, the state could not deny students with mental retardation access to free public education and training. And they said that the earlier the students with mental retardation were provided education, the greater the amount of learning that could be predicted. A point related to denying preschoolers with retardation access to preschool programming available to children with disabilities. So they talked about those 4 points and really brought up the point equal access. So this was resolved by consent agreement specifying that all children with mental retardation in Pennsylvania between the ages of 6 and 21 must be provided a free public education, and that it was most desirable to educate children with mental retardation in a program that was most like the programs provided for their peers without disabilities. And this set the stage for continued developments regarding the education rights of students with disabilities. So then Mills versus D.C. Board of Education was a class action suit filed, and this was filed against District of Columbia Board of Education on behalf of all out-of-school students with disabilities. So it wasn't just about mental retardation, it was about all students out of school, no matter what their disability was. It was filed by parents and guardians of 7 children who had a variety of disabilities. These students were certified as a class and so represented more than 18,000 students who were denied or excluded from public education in Washington, D.C. And it was based on the 14th Amendment and said that students were improperly excluded from school without due process of law. It expanded on the park by adding other handicapping conditions, and it added in rights for parents to be involved in decision making. The court held that because segregation in public education on the basis of race was now unconstitutional, the total exclusion of students with disabilities was also unconstitutional. The case resulted in a judgment against the defendant school board and mandated that the board provide all children with disabilities a publicly supported education, and it ordered the district to provide due process safeguards. It clearly outlined due process procedures for labeling, placement, and exclusion of students with disabilities. So this was really important and built on the Brown case that said that it was illegal to segregate students. And so students with disabilities pulled on that case from the civil rights and brought it to bear for them, and said that because it was illegal to deny access to school based on race, it was also illegal to deny access to school based on disability. And the courts now agreed. And this was in 1972. So in 1975, we had a really important law that was passed, PL 94142, the Education for All Handicapped Children Act. This was strongly supported by the Council for Exceptional Children, and it said that public schools were required to evaluate handicapped children and to create an educational plan or an IEP with parent input that would emulate as closely as possible the educational experience of non-disabled students. So they said whatever the non-disabled students are getting, whatever general education students are getting, students with disabilities should also be able to have equal access. It said that we should all have a free and appropriate education in the least restrictive environment for all children with disabilities, and that they should provide procedural safeguards necessary to ensure equal access to public education. So in 1977, the Education for All Handicapped Children was amended, so they extended authority. In 1983, it was amended again, and it strengthened support programs to encourage integration of children with severe disabilities, including creation of severely handicapped institutes. It promoted transition from school to adult living, and it required least restrictive environment. In 1986, the Education of the Handicapped Act amended again, and it established a phase-in of free appropriate public education for preschool children from 3 through 5 years of age, and it created an early intervention program for infants and toddlers from birth to 3 years of age. And it also authorized a state-of-the-art program for technology and for educational media and materials. In 1990, the Education for All Handicapped Children Act was amended again, and this time they changed it from PL 94142 to the Individuals with Disabilities Act, or IDEA. So the name changed. It added transition services to the required content of the IEP. It added traumatic brain injury and autism to the disability categories, and it established the Parent Training and Information Center system on a nationwide basis. So each time the laws are amended, they're revised in some way. So this law has been happening since 1972, but it's changed a number of times. Things have been added to it, and the name has changed. So PL 94142, or the Education for All Handicapped Children Act, became IDEA. In 1997, IDEA was amended. It strengthened the relationship to the general ed curriculum. It said that we need to have students more involved with the general ed curriculum, those students with disabilities. It's important that they take part in that education curriculum, that there's one curriculum and not a special ed curriculum and a gen ed curriculum. It revised the evaluation and reevaluation provisions for finding and identifying students with disabilities. It added new stipulations in the IEP regarding state and district-wide testing, and it designed procedures related to behavior and discipline. So a lot of changes happening and moving forward. In 2001, the No Child Left Behind Act was passed, and the big piece was this, with this one is, this talked about all children, not gen ed, not just general education students, not just special education students, but all children. And it really focused on increased accountability for schools and teachers. It supported standard-based education based on the thought that setting high standards and establishing measurable goals could improve individual outcomes in education. So it was about accountability and raising the standards for all students. And this was where it required states to develop assessments, to test basic skills, to make sure that students were being provided with the education that they needed and that they were passing on the level that they needed to be at. And once again, this was talking about all children, not just students with disabilities or not just gen ed. So all means all. Then in 2004, the Individuals with Disabilities Education Act was amended once again. It coordinated procedures and policies with those of No Child Left Behind. So it was moving more towards access, equal access for everybody, high standards for students with disabilities, and raising the bar, getting those students with disabilities into the general education curriculum more often. That's the work that they were trying to get to. Now, we just had an important event, and that was that the No Child Left Behind Act has been replaced with Every Student Succeeds Act, and that was just signed in December 10th, 2015. And I've provided you with a link to go read about that, and there's a video to also watch. And we're going to talk more in depth about this act as we move into the second week of class. So at present, special education has changed starting in the 1800s. It was more about the Civil Rights Act, but also there were some cases related to disabilities and equal access to education and the segregation of schools. So it's evolved since those first steps in the 1800s. So we've made it into the same building as everybody else, but the work's not finished. We are still working on getting students with disabilities into general education classrooms for more of their educational day. It's important for students with disabilities to have access to the gen ed curriculum. It may be the right thing, but it's not something that just happens as a matter of course. There's still a pervasive attitude of your students and our students. Such for the presence of the legal and the legislation and all of the laws that have been put into place, the procedural safeguards that have been put into place to make sure that students with disabilities are being offered equal access to education. So there's still work to do. This is an article that was in the Boston Globe in January 23rd, 2007, said Rhode Island schools keep many special ed students in separate classes. Nearly 3 out of every 10 of Rhode Island's special ed students are being educated in separate classrooms, despite research and a federal law that says the students perform better in regular classes. So even though the laws are out there, people still aren't doing what needs to be done. So your role as a special educator will change continuously. You have to be a leader, you have to be an advocate, you have to educate your students, you have to educate other educators, the students' parents. You are a resource to all those, to the educators, the parents, and the students. You have to be a creative problem solver in many cases because one of your jobs is to advocate to get those students into the gen ed classroom. You have to be a lifelong learner because you have to keep up on all of the changes in the legal system, and as you can see, it happens fairly quickly. They don't always come out fast, but there are a lot of changes and a lot of rules that are coming out that you have to be aware of as a special educator. So based on the information that I've provided, if you have any questions, please contact me to discuss them. Use the virtual office, send me an email, call if needed. You can always text me. My contact information is in my virtual office. Thanks.